Hi everyone, and welcome to a new episode of our Law and Influencer Order series. We live in a world full of information, and yet many social media users don't know the laws or their rights and obligations regarding it. That's where we come in. We're a group of students from Maastricht University Influencer Law Clinic who take social media drama and analyze it from a legal perspective. In this video, we will discuss what you should take into account when uploading videos to social media, which aren't necessarily 100% yours. In law, the general umbrella of the rights and obligations you have in this context is called intellectual property law, or IP law for short. This video will focus on a part of IP which applies to video content, namely copyright. As a short disclaimer, this video is meant to explain how the law works. If you need more information about how this research applies to your specific situation, please contact us at the Influencer Law Clinic and we can give you a more tailored research overview about this specific legal issue. In YouTube, there is a system aimed at copyright protection where if someone thinks that a video is stealing or otherwise violating their video, they can claim a video they think is in violation. This can lead to different things, most notably the fact that there might be a stop on the video's monetization, meaning the creator would not get paid a share of the advertising shown on the video. These claims can be fought with counterclaims and appeals either through YouTube or straight to one making the claim. Then, put into context, you have just released a video in YouTube in which you reference the work of someone else. This video then gets claimed and you don't get any revenue from it. Or it might just get taken down completely. You look at the reason for this and it says you have infringed someone's copyright and you have no idea what you have done wrong. Don't you own the video that you have made? Copyright is one of those words which must be familiar to any influencer. But what does copyright actually mean? By breaking it down to bits, copyright is the exclusive right of the creator of an original work to authorize or prohibit certain acts relating to that work. Currently, in Europe, the basic legal rules for copyright comes from the EU Copyright Directive. Although this is European law, it is still very much applicable in all 28 countries belonging to the EU. In the current EU Copyright Directive, named Directive on the Harmonization of Certain Aspects of Copyright and Related Rights in the Information Society, copyright is a right which contains rights to reproduce, communicate, make available, right for the adaptations of your work, and to distribution of your work. We must also make a distinction between the differentiation of EU copyright laws. This copyright directive has been in force since the early 2000s. Meaning it might be different from the one of which you might have heard recently through the news or social media. That directive is called the Directive on Digital Single Market, and the 28 member states have until 2021 to implement this directive. So in essence, you the creator create a work, which in this example is a video that you produced and released to the public with the possible aim of profiting off of that video. You do not need to register a copyright for the work you created in order to decide what happens to that work or who benefits off from it. This is because unlike other intellectual property rights, such as patents or trademarks, copyright exists automatically from the moment you create that work. This is an international standard found in the Berne Convention, Article 5.2, which states that the enjoyment and exercise of the copyright shall not be subject to any formality. There are some slight differences in national law, but in most European countries and the United States, a work only needs to be expressed in some way in order to get the copyright for that work, which means protection in a sense. This also means that if you are sitting on a masterpiece movie, which then someone else shares before you, they would in effect have the copyright for that movie. The only real requirement on top of making your work public is that the work is original. This means that the work has to be a result of an author's own creativity. This is called the originality requirement. The Court of Justice of the European Union has ruled in multiple cases that the concept of a work is a harmonized concept. The most important case to mention here is the InfoPack case of 2009, where the court took a stand saying that in fact the creativity in author's own creation is in the core of the copyright and that all member states should interpret exceptions and limitation according to a general principle of interpretation. More on that in a bit. So how then your video can be, for example, claimed in YouTube for allegedly infringing on somebody else's copyright? This is a very common problem in the social media sphere due to the fact that a copyright can exist for many different things. For example, a YouTube video can be composed of many different parts, music, effects, clips, etc., all of which have a separate copyright to them. If you have not created all of those parts of the video, that usually means that you're taking advantage of someone else's copyrighted material. Therefore, if I make a video discussing my favorite Netflix series and I show a clip of that show, I am indeed infringing on Netflix's copyright to that show, and then Netflix can technically claim my video. This is especially true if I profit off of that video, which then Netflix can point and say that I am in fact profiting, at least in part, from their work, as it forms a part of my video. The same logic and argument goes if I use copyrighted music throughout the video. The more I use, and the more prominent someone else's work, is the better claim they have to my video, which sometimes may even result in them getting the money that my video makes. This all comes back to the requirement of originality. As example, in the Painter case, the Court Justice of the European Union emphasized that the most important part of originality is whether I, as a creator, have made independent creative choices reflecting my personality. If I have indeed made such choices, the work is considered original and protected by copyright. But as always in law, there are exceptions. The European Union has a plethora of situations where the use of someone else's copyrighted material is allowed. In the current copyright directive, these conditions are found under Article 5 of the directive. The EU has a closed list of situations where copyright infringement, such as use in another video without permission, is justified. There's a concrete list of exceptions, such as the use in education or as parody, but also there are two concepts which seem to mirror the US fair use doctrine, which operates more on a common sense basis. First, there is the Article 5.3.0, called the Grandfather Clause, which allows the use in some minor cases. Second, there is the Article 5.5, which states that limitations to use shall only be applied in cases which do not conflict the normal exploitation of the work. Although the article with its paragraphs and subparagraphs are complicated, a good rule of thumb is that the lesser your economic intent and reliance on the other work is, the bigger chance there is for your work to fall under that exception. These exceptions are further elaborated in national law, where maybe even more concrete situations are given. But, in principle, the situations do not differ much between different member states of the EU. To step away from the legal language, in my previous example of using a Netflix clip, if I were to use that clip in a critique or a parody as per Article 5.3k, or in a minor way as per Article 5.3.0, or in a way that does not conflict with normal exploitation of work as per Article 5.5, I could get the claim probably removed from my video and continue to monetize it. YouTube is conducting its copyright policy in Europe through the lens of appropriate use, which is an amalgamation most probably meant to indicate a European view of the fair use doctrine most commonly used in the US. This results in a situation where it is always better to do all of your own work by yourself from the ground up. But in this virtual economy, in some cases the fair use of someone else's work might be allowed. To however combat this, I would recommend using work or music which state to be free to use or of others which you know for sure will not claim your work. You can find these kind of resources, for example, in freesound.com or pixabay.com. If, however, there has been, for example, an abuse of the claim system to works which are definitely under their own copyright, there are multiple ways to fight this. First, you can try to solve the issue through YouTube's own mediation platform. Second, you can contact the copyright associations of your home country, which usually provide free legal help. And third, the most severe measure would be to challenge the abuser in court. This, however, is rarely viable, as the legal costs can often severely outweigh their goals.